who come for the simple order are saying, look, we are in this party, the rival group is in this party, please decide who's the real party. So 2-1A will never apply. What is 2-1B? You violate the whip. So the role of disqualification is basically a person who gets elected on a particular ticket, then leaves the party and comes to it, then you get disqualified.
The only point really, Mr. Datar, is that the issue of giving up the membership of a political party within the meaning of 2-1A is not confined to your activities within the House.
Yes. In my submission, what I would submit, that will partly depend on, because what I'm submitting is, if
because voluntarily giving up the membership of a political party is not confined to what you do within the folds of the House. Unlike 2-1B, which is votes or abstains from voting in the House.
Yes.
But 2-1A is much broader.
True.
Voluntarily gives up membership of a political party.
No, I'm sorry. I absolutely no.
And therefore, the Speaker's power to determine that is not therefore confined to what takes place within the fold of the House.
Lordship will see there are case laws which say, what is the meaning of voluntarily giving up membership? There are judgments which say, a particular member of party X has attended all the meetings of party Y. He has participated in the functions of party Y. Then has he given up his party or not? So in some cases they say, yes, it's amongst giving up membership. But that's really outside the scope of this reference. That's why so if you say voluntary, Lordship is right. That's why under clause 6, the Speaker is called upon to say that Mr. X, he attended the rallies of this party. But the reported judgments are there, I can circulate them. He attended the rallies of this party. He attended the meetings of this party. He was seen in this particular party. The Supreme Court has said no, but his name is still continuing in the register of members, therefore he has not given up. In 2 cases, they said this itself indicates that he has given up his membership. So is it it can be impliedly giving up also, physically actually giving up also. But what I'm submitting is,
but one thing is very clear that 2-1A as well as 2-1B is member specific.
Member specific.
15 is not in that sense member specific. It deals with a faction as to whether a particular faction represents a political party.
Now, Lordship will come.
It refers to a collective group as to whether that represents a political
party. Now, Lordship will come. Yes. So, what I'm submitting is, paragraph 15 basically refers to the collective right, the collective party. Who is the real party? And if your Lordship now comes to paragraph 15, which your Lordship saw a number of times, I will go through it again. And if your Lordship has seen Sadiq Ali several times, I won't repeat it. But the first 2 paragraphs are very interesting. How did this problem straight away come about? Because Nijalingappa came to the Congress so, and Jagjeevan Ram was Congress. We've all gone through the controversy in those days, the Congress so, the Congress, etc. And then the argument was that the Congress who had majority in the Congress Working Committee. Lordship, can you just assist your broad outline of that case?
Sadiq Ali is of which year actually?
1975.
75.
But this took place in
1969.
Yes.
We were, so in that sense, Sadiq Ali was doing a bit of a postmortem on what happened.
No, but what happened was because just Sena remarks in an abnormally prolix order. The prolix itself is abnormal, but his Lordship says abnormally prolix order of 437 pages. The Election Commission has drawn. There, what happened was, Lordship will just keep on just 2 points. Lordship will know. Sadiq Ali deals with 72 Supreme. Sorry. It's Sadiq Ali says 72-4 SCC 662. Sadiq Ali says the Election Commission went by 2 tests and that Supreme Court approved. One was the test of majority. Test of majority qua Parliament and individual houses. They took the strength of the Congress in the Lok Sabha, in the Rajya Sabha, in the individual houses, and they said that out of these number of MPs, X are in the Jagjeevan Ram faction. Why are they the Nijalingappa faction? They go statewide. But you want to see that, I can show that later. That's the break. Then they say, at the All India Congress Committee, Working Committee, where more than some 2,000 odd members were there, a large majority voted for this particular group. And therefore, the election came to the conclusion that the actual Congress was the Congress J and not the Congress O. And the court said nothing wrong with it because they have gone by test of majority in this. The point is not what we adopt. The point is, Election Commission is free to decide as to how it tests the majority. And by and large, what they're doing is, and I've got cases in my compilation. We had recently problems in Tamil Nadu where who was the correct member of the All India NRDMK. Hearings took place, they came right up to the Supreme Court. And what the Election Commission they take a complaint, ask both parties to give their submissions, then evidence, affidavits, etc. are admitted, and then inquiry is done. Now, please see my notice under para 15. I am humbly submitting that this notice has nothing to do with the bench. Chapter. Lordship will kindly see out. Yeah, please see the page. Please see my notice page. No. The notice section 15 notice.
44, page 44.
Yeah. Lordship will see para 40, page 44 of R4's compilation, volume 1. 22nd July 22.
Document.
Yes. Document number 9. My lord is gone.
Document number 9.
What is it? What
It's
is
in the
it?
Sadiq Ali compilation.
No. It is the compilation of respondent number 4. Volume 1, respondent number 4, compilation of documents and rules. And this is document number 9.
Notice
Yes.
of 22nd.
22nd, your my lord is right. 22/7/2022.
Page number?
Page 44. So the pages are coming at the bottom.
Yeah. We have got total 118 page.
Yes. Lordship will kindly see the notice is sent to both and then subject so and so. After the preamble, kindly come to para 2. The commission is in receipt of communications as delineated below. She is so and so member of parliament and secretary of party on 25/6/22 intimated the commission about the alleged anti-party activities carried out by some of the MLAs under the leadership of so and so, and objected to establishing any political party using the names Sena or Bala Sahib. Anil so and so forwarded 3 letters dated so and so, and so he gives a comment. Then Sri Anil so further email it an affidavit of so and so. Now kindly come to E. Sri Eknath Shinde on 19/7/22 filed a petition before the commission titled that so and so on the para 15 of the election symbols to declare the group led by Eknath Shinde as Shiv Sena and allot the party symbol of bow and arrow to the group. Eknath Shinde, the above petition, I mentioned that. Then he goes on to 1, 2, 3, 4, 5, 6. Now please come to para 3 at page 47. Now this is the standard format we file whenever we get a complaint. We say who has made the petition, what is the gist of this complaint, what is the other side. Please come to para 3. Para 15 of the election symbols and reservation allotment order 1968 provide that the commission is satisfied on information, your lordship see para 15, I won't read it again. On due consideration of the totality of information available on record with the commission as summarized above, the commission of this of opinion that there are 2 rival groups in Shiv Sena party, one led by Uddhavji Balasaheb Thackeray and the other led by Eknath Rao Sambhaji Shinde. Each group is now claiming to be the party, and therefore the matter requires a substantive determination by the commission under para 15 of the election symbols. In order to place both the rival groups on even keel and to protect their rights and interests, and going by the past precedents, the commission has directed the documents submitted by the rival group be exchanged and the reply written submissions be invited from the 2 groups. The steps envisaged under para 15 proceedings prior to the hearing rival groups they require both rival groups to submit the respective documentary evidence of the support claimed by them, the organizational and legislative wings of the parties. Accordingly, Commission has directed both the group to furnish written submissions and their respective documents to support their claims by 8th August 2020. But when the matter came up, I told the court that this is just the first step. There is no need to stop me. Let all the inquiry go on, by the matter. But then the court said, please, furnish documents you asked for. Now, if your lordship sees the notice, it has got nothing to do with the membership of any person of the party or of any house. There is an MP or an MLA. Secondly, my lord, by submitting this application by respective sites, none of the provisions of 10 schedule are attracted. Because 10 schedule disqualification is limited to 2(1)A, 2(1)B. So my submission is, as somebody mentioned, para 15 is like the inner party democracy. Suppose as the party grows, there are bound to be groups, bound to be factions, and ultimately who claims superiority? There is no floor to test the house. So only way election can do is to get documents, get affidavits, listen to the parties, and then decide. Now, Lordship will just see how we have done it in one case from Tamil Nadu. Is that Anna DM?
I don't think we need to go into the issue.
No, what I'm saying is because Lordship will see number of advocates have appeared, numerous documents have been filed, hearing has been conducted. Yeah.
So, Datta, you have already said so in your paragraph 3, the procedure to be followed by the election commission.
Correct.
You have already stated so.
Thank you, Mr.
Yeah.
Datta.
So my humble submission is not only in this case, but as a general rule, my humble submission is whatever happens on the floor of any particular House of Parliament, that will be completely independent. It will not impact the function of the Election Commission in any case at all. Two things can happen. Either Lordship may allow the petition or dismiss the petition. The result of the para 15 order will be completely independent of that. Whether a person is disqualified or not disqualified. He doesn't cease to be a member of the political party. And we have to go by the majority of the members of the political party, not of the legislature party. The impact of strength will be on the legislature party, but not on the political.
Yes.
Thank you.
Thank you, Mr. Datta. Yes, Mr.
My friend is right. These two, 10 schedule and para 15 operate in different silos. Then he's right. That's what your lordships have to decide. My lord made a very important and significant comment. A lot of these issues in respect of voluntarily giving up membership of the party doesn't happen in the House. The party doesn't happen in the House. You go to Gujarat, hobnob with the opposition. Then you go to Guwahati. From there, you are sending notices. Then you accompany the leadership of the BJP to the governor. All this is not within the House. All this is outside the House. And the Speaker will have to consider, for the purposes of coming to the conclusion, whether you are voluntarily giving up membership of the party, not the House. It is because of that you are disqualified in the House. Giving up membership of the party outside the House amounts to disqualification within the House. So you can't say one is different from the other. What happens in the House is unrelated to what happens outside the House. And the Election Commission can't say, I'm not concerned with any of that. Number two, Manoj, in paragraph 2(1)B, if you vote against the whip, you will be disqualified not just under 2(1)B, but also under 2(1)A. Once you violate the whip, Manoj, not only have you expressed yourself that you are voting contrary to the whip, you are also saying, I'm no longer a member of your party, but I'm not bound by your whip. That's the constitutional position. With the greatest respect to my learned friends, Manoj, they are completely misled, Manoj, the decision of this court in Rajendra Singh Rana. Let me just give you a notice briefly what it was. Of the BSP, joint hands with the Samajwadi. Now, there were 109 members of the House. The speaker gave notice, nothing. He did nothing. After a few weeks, 24 more of them joined. So they became 37. Then the speaker said, this 37 is 1/3. And because this 37 is 1/3, therefore they are protected under the 10th schedule, because at that time paragraph 3 was there. This court said no. You have to decide on the day when 13 members went to the speaker. Even at that time, not 1/3. The speaker wrongly allowed 1/3 to develop to give protection to the 10th schedule under paragraph. Therefore, the disqualification relates back to the time when the 13 members approached. Speaker. That's one part of it. My argument is completely wrong. That is unrelated to the issue of giving up membership of the House. Of giving up membership of the House. When paragraph 3 was, before it was deleted, paragraph 3 was, before it was deleted, integrally linked with the political party. It is integrally linked with the political party. Only see our compilation of statutes. Only see our compilation of statutes. What's it? Paragraph 3.
You can read it out, Mr.
Sorry. He says not given to the court. Sorry.
That's in the footnote. And it's not in the footnote. This footnote doesn't have it actually.
I'm sorry.
No, that's all right. Just read it.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction. And you see, Mother, the correlation of this with paragraph 15, which has arisen as a result of a split in the original political party. It's 115 of their compilation. Have a look at that. Better Mother, we did. You can. And such group consists of not less than 1/3 of the members of such legislature party. He shall not be disqualified. So what does it say? A member of a house who claims that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. So when the speaker decides in the paragraph 3, Rajinder Singh Rana says, merely because you make a claim is not enough. The speaker will have to prima facie decide that there has been a split in the original political party. It's not a question only of the legislature. And that is reflected in paragraph 37, 36 and 37. You just read 37 because that's why I wasted time with it. But this is 1074 SCC model I have. In their compilation is 192. Para 37. I'm reading 36 and 37. 192 models probably. 219, my lords. Plus 219, they are quoting Jagdeep Singh Miller's paragraph 69, the lords. My lord, just that's in italics. Not in italics, but in intention. My lords have that. Apart from the above, the acceptance of the contention that only a claim is to be made to satisfy the requirements of paragraph 3 can lead to absurd consequences, besides the elementary principle that whoever makes a claim has to establish. It will also mean that when a claim as to a split is made by a member before the speaker, so as to take benefit of paragraph 3, the speaker, without being satisfied even prima facie about the genuineness and bona fides of the claim, has to accept it. It will also mean that even by raising a frivolous claim of split of original political party, a member can be said to have satisfied the stipulation of paragraph 3. The acceptance of such a broad proposition would defeat the object of defection law, namely to deal with the evil of political defection sternly. We are of the view that for the purposes of paragraph 3, mere making of claim is not sufficient. Prima facie proof of such a split is necessary to be produced before the speaker so as to satisfy him when such split has taken place. This is contrary to what my learned friend argued, completely contrary. Now see 37. Thus, in the above decision, it has been clarified that it is not enough that a claim is made to have a split in the original political party, in addition to showing that 1/3 of the members of the legislative party have come out of the party, but it is necessary to prove it at least prima facie. Those who have left the party will have prima facie to show by relevant materials that there has been a split in the original political party. And my learned friend argued that no, in Rajendra Singh Rana, they have said we are the original political party is not concerned with the split in the legislature. It's just the contrary. The argument, therefore, that all of the other than 37 MLAs required to do so was to make a claim before the speaker that there has been a split in the original political party, and to show that 1/3 of the members of the legislative party have come out, and they need not produce any material in support of the split in the original political party cannot be accepted. The argument that the ratio of the decision and justice required to be reconsidered does not appeal to us. Even going by Ravi Naik, it could not be said that the learned judges have held that a mere claim in that behalf is enough. Now, what's important here, and this is the significant part, having done away with paragraph 3, now consider the consequence. Now there is no question of majority minority. There is no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shiv Sena. I am recognized by the speaker as the Shiv Sena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. There are 34 of this judgment clause. The act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the way wished to him. Therefore, the act that constitutes disqualification in terms of para 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. If it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do is to decide the status of the party, so-called party, on 19th of July. What will happen on the 19th of July thereafter has nothing to do with what's happened before, because what has happened before is that they have given up the membership of the party. Let's ask the question, a very important question that we threw him out of the post. But let's see our head. Volume 2. First, we'll show the letter to the Election Commission. Now, let us kindly see the letter we wrote to Sindhi on the 30th of June. It's much before 19 July. At page 321. Convenience compilation, volume 2, page 321.
Yes.
Dear Mr. Shiv Shinde, you have been indulging in anti-party activities and have also voluntarily given up membership of Shiv Sena. Therefore, in exercise of power vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So, Malas, I tell him that you have already by wax given up membership of the party. So it's not a question, Malas, of removing him from the post. Now see the letter we write to the commission at page 333. This is on the 1st of July.
Yes.
Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shiv Sena. Consequently, he was removed from the position of Shiv Sena leader in the party organization set up by Shiv Sena Paksh Pramukh Shri Uddhav Thackeray in terms of party. Just to mention that he was not an elected member in the party organization. He was nominated by the leader. Uddhav Thackeray is the president of the party from 1990 to 1923. I still remain the president of the party. Even now. Sorry, 2018 to 2023. As per the records of the election commission. So I remove him. He was a nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, Malas, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which he is disqualified by virtue of 218. My learned friends are saying that this has nothing to do with the election commission. As a matter of constitutional law, how is that possible? In other words, the election commission will decide and will presume as a matter of law that he continues to be a member of the party. Whereas this under the 10th schedule, by his acts, he is no longer a member of the party. So, Manas, how is that possible to say that no, these are two different cycles? Now, Manas, and therefore, Manas, I'm saying because there is no defense now available under the 10th schedule at all as far as paragraph 3 is concerned or any other paragraph is concerned. The only defense available is merger. And in the context of merger, Manas, if your lordship looks at paragraph 4, just give me a minute. Very interesting. Should not be disqualified under subparagraph of paragraph 2, where a regional political party merges with another political party. And he claims that he and any other members of the original political party have become members of some other political party. So, Manas, if he is a member of the Shiv Sena and Shiv Sena merges with somebody else, the stand of Shiv Sena is effaced. He is no longer Shiv Sena. He merges with another party, or he has another party merge with him and he forms a new party. the new party or the merged party becomes his original political party. I hope I made myself clear.
Yeah.
So it becomes his original political party, so he's washed his hands off from himself. That's the consequence of paragraph 4. Then he can't maintain a petition under paragraph 15. Because he's either merged or he's found a new political party. And those who are left behind, that is, who are less than one third, because 2/3 makes others, those belong to the original political. In this case, Malad, us, of course, in the absence of a merger. So, therefore, the nomenclature of the original political party, which was attractive when they were first elected to the House, they've lost that in the paragraph. Now, see what my learned friend read. He said, please read the last part. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Naturally, because we are now talking about formation of a new party. Therefore, you are no longer the original political party. This will take a bit of time.
Mr. Sibal, you can conclude your argument.
No, you are in rejoinder council.
They have argued for this.
No, that cannot be tit. No, that cannot be tit for tat that he has taken 2 hours.
All right, you again, Mr. Sibal, you can deal with the judgments. You can tell us what the point of distinction, what we've been noting along is you go along and what the point of difference is.
I have no problem. I can finish it. Now, therefore, now let's come to paragraph D.
Paragraph D of
Okay. Our my colleague Maninder Singh cited paragraph D of our petition.
Okay, the ground. Ground.
I yes, the grounds. Over your prayers.
What I was saying is there are certain judgments that have been cited which are wholly inapplicable. I just want to point out that Kerala judgment, there are 2 other judgments. It's all right. Read the whole paragraph.
No,
Let's read the whole paragraph.
Ground D of ground page 8, right?
Because and children. That's the point, Manu.
But that will be considered, Mr. Council, at the time when we consider the question of disqualification.
But if you lordship allow the election commission to go on and hold, and that's the point, brothers. Either your lordship says one has nothing to do with the other, and if your lordship is saying you will consider it at that time, that means that has something to do with the other.
And
I'm not saying I'm only saying, brothers. He says these are great repercussions because in this situation,
then X number of people of a political party who are in power can be named away. Governor will give them votes, and we'll go to the election commission and say, you declare us the civil wars. And
that's the consequence,
which is sought to be prevented by taking away the third paragraph, paragraph 3 of the 10th schedule. The whole purpose of taking away paragraph 3 is let's not have these spits.
Then paragraph 36 minutes. Also read it half of it. I'll just read that minute. Page 10. On the contents of paragraph 24 to the 24 to 32 are denied. It is submitted that clearly claiming the support of a majority of SSLP cannot be looked at in isolation. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the very first place itself. Having committed a series of anti-party activities culminating in the blatant violation of Whip 37 as well as of 47, and having read the writing on the wall as to their imminent disqualification from membership of the Assembly, the splinter group has now rushed to the Election Commission to claim that they are the real Sena. Well, this is what they did. They did it on the 19th of July, knowing full well that the writing is on the wall. My learned friend cited two other judgments. First, Kerala judgment where there was no disqualification.
2021 4K 23 he said at page 50.
Well, then,
But he didn't read it out.
Let's see Palaniswamy, whether he cited.
Palaniswamy.
Well, that is a pure issue of why the matter was pending before the commission. I myself argued it. The question is, who should the symbol go to, or should it be frozen? Interim symbol, which has nothing to do with the tension. Palaniswamy had nothing to do with the tension. Matter was pending before the commission. There were rival claims. And the question was, who should get in the interim symbol? What has that got to do with this issue? The third judgment my learned friend cited is the Kerala judgment. So that my colleague.
That Mr.
Jetmalani cited.
He didn't cite.
Para 4, Mother.
He really just gave us a citation.
Yes, no doubt.
No, he said that this is the first time the
page,
court has decided.
at page 51.
Yes, now, Mother, I just note para 6 of that judgment says the learned single judge has also failed to appreciate the fact that even when the writ petitioners claim that rival groups exist in the party and their group is the party, no petition under the 10th schedule has been preferred. It's not a case of the 10th schedule at all. Para 6 at page 172, 3 mothers. Para 6.
At page 173.
Yes. It's not a case, Malad, of any application also for disqualifications. Then he cited Kanhaiyalal Umar. Now, Kanhaiyalal Umar, Malad, it is a writ petition challenging the power of the commission under the symbol law. The violence of the symbol law. What has that got to do with disqualification? That's Kanhaiyalal. Then well as all party hills leaders conference, brother. That was a case. The election commission is a tribunal for the purposes of 136 before 1985. one led by Uddhav Thackeray. So you assume this, Malad, on what basis do you assume this? And each group is now claiming the party. That's not my claim. I am saying he's no longer in the party, he's voluntarily given up. How does on what basis does the election commission come to that? Assume that fact. Let us require substantive. Now see next fact. In order even this is very strange. Both the rival groups on even key. Where does he get that from? So what the election commission is doing is, I don't care what's happening under the 10th schedule. I'm not bothered what's happening under the 10th schedule. Even if you are deemed to be disqualified, even if you are voluntarily given up membership of the party, I will treat you on an even keel. I will assume you are still a member of the party. Whereas the election commission can't assume that. We have already written to the election commission that look, he is no longer a member of the party. He is voluntarily given up. So on what basis does he say not even keel? And to protect their rights and interests and going by the past precedent, commission has directed that the documents submitted by the rival group be exchanged and replied. Even then, then was interesting. The steps envisaged under paragraph 15, prior to hearing of two rival groups or others, if any, inter alia require both rival groups to submit their respective documentary evidence to support claimed by them in the organizational and legislative wings of the party. Now that's very important. So three elements in these notices, which according to me are completely contrary to the record. Malas, they are aware of my letter, Malas, at paragraph 2, Malas, 2A. Sorry, 2B. Anil Desai by email forwarded 3 letters whereby it was mentioned that the following members have been judged in anti-party activities and have voluntarily given up membership of the party. Now, commission can't decide that issue. So now let's go back to the last part, 702 that I was reading. Support claimed by them in organizational and legislative wings. Let's just pause here for a minute. Just reflect on what happened. The 30th of June, they were all sitting outside. There was no organizational wing. They were in Guwahati. They were sending letters from Guwahati that I throw you out, I am the person, I am the chief whip. Gogavli is the chief whip. Your person. Where was the organization? There was no organization. There was no activity in the organization. Evidence of support claimed by them in the organization. There was no support claimed by them in the organization until the 30th of June. Even after that, there was no support. It only comes later. Secondly, on the legislative wing, your lordship knows that in the paragraph 15. The very foundation of it is lacking. You are presuming a foundation which doesn't exist. You are presuming that they are members of the state Sena when they are voluntarily resigned. I have informed you about it. And you say we treat it as an even case. Nobody disputes whether than a big argument is made about 324. Nobody disputes that power. Who disputes the plenary power of the election commission? Not I. We're talking about the interrelationship between proceedings under the 10th schedule and proceedings before the election commission to decide on symbols when one impacts the other. And the priority is whoever started proceedings first to be given priority in terms of decision making. If it is an afterthought, then after everything has happened and you have voluntarily given up membership of the party and thrown out an elected government, then you go to the election commission on the 19th of July and say, I am the party mother. Certainly, the election commission can't get precedence.
Now, as far as plenary power is concerned, and this is the last point I wish to make. Paragraph 15 deals with an admitted position that we are all members of the same party. That's how Para 15 came into existence in 1968. There was no question of tension. There was no question of defection. And what used to happen? The history of litigation in this area would show that every faction used to throw out members of the other faction. And obviously, election commission could not decide those issues. So they say, okay, let both factions come in, we'll see who has the support. But that the foundation of that went away the moment the 10th schedule came. Then the question of factions didn't arise. Then the question of disqualification came. The purpose being that those who are disqualified cannot get the symbol of the party. Because they have voluntarily given up membership of the party. Otherwise, why have that? Why we have 2-1 at all? It is only a question of the legislature. Argument was this all relates to the legislature, that relates to the party. But then why have 2-1 at all? So Para 15 presupposes legitimacy in the context of party and two factions arising out of legitimate membership claiming to be that party. Para 15. Para 15 doesn't allow the election commission to disregard what has happened under the 10th schedule. Because if it does, what will happen is, supposing your lordships decide in my favor, let's assume your lordship will decide in my favor ultimately in the petition, what will happen? They will say, we are the party. Now what's left in this matter? Unturn the clock back. Election commission has decided. So it makes my petition infectious. If our lordship decide against me and say, no, what happened was perfectly legal, in any case, they will get the symbol. Go before the election commission so that the either freezes the symbol or gives it to somebody without having this matter decided. And then they say, look, my speaker is there. My speaker will decide. Well, how will the speaker decide? Because this court has said on the 29th of June that everything that has happened after 29th of June is subject to the orders of the court. They must have glossed over. So how will the speaker decide that issue? And then the larger question is whether when you go to the deputy speaker, that you are disqualified because we have moved a notice of removal against you, mother. The speaker said this hasn't come from any source at all. It has come from an email that I am not even aware of. It has come, and it is rejected. And that fact is suppressed when they come to this court. And mothers, what's interesting is this course, and I'm sorry, mothers, I'm taking time, I didn't want to take too much time to watch it. But let's see what the order of the court is on the 27th. Then show me Kyoto. It says, meanwhile, as in intent, sorry. Yeah.
So what is the date of the order?
Date is the 27th of June.
PDF 2151.
2151.
Compilation of orders and pleadings is there in page C, mothers.
Thanks. Yeah.
Meanwhile, as an interim measure, because it's about a few paragraphs.
Yes, we've got that.
On
Yeah,
page 3.
meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Assembly to submit their written submissions up to today by 5:30 is extended to 12/7/2022. Correct, Miller? Now see Kyoto Holo. Para 110. The argument is he gave us 2 days time. He gave us 2 days time. Natural justice. That's the argument. Therefore, this court extended it. Now let us see the order. See Kyoto government. Para 110. Order is in the teeth of five the constitutional bench of this court. Then the government was offered. Then we came to court that look, the consequences of this is the government will topple. Then the judge said on 29th, but it is all subject to what we will decide. What does Kyoto say? I'll read it. No need for your option. In view of the limited scope of judicial review, it is available from para 6. And also having regard to the constitutional intent of the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review prior to the making of a decision by the Speaker, Chairman, and a legitimate action would not be permissible, nor would it be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceeding. And such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. There is no power to interdite the proceedings. It is only after the decision is taken that you can challenge it. That's the constitutional judgment. So where is the question of coming to court and saying you gave me only 2 days notice? Wait for the decision of the Speaker, you challenge it. The result was, because the court extended it for X number of days, the government toppled. And then we came to court and said, in fact, I remember I had told the court that this is what's going to happen tomorrow, which is simple, why do you worry? We have passed an order saying everything is subject. Now they are saying it doesn't matter. And what is this inner party democracy? I have not understood. Inner party democracy in the context of 10th schedule means what? That you can topple any government you want to topple by joining hands with the opposition. It makes no difference. Inner party democracy is in the context you are continuing to be a member of the party, not doing anti-party activity, and air your grievances within the forum of the party. Inner party democracy doesn't mean that you violate the 10th schedule and say I have the right to violate it, and this is inner party democracy that's been given up. So this concept of inner party democracy by violating the 10th schedule, not going to the organization, staying in Ahmedabad and Guwahati, doing acts outside the house, and then going to the election commission on 19th of July when you've done what you had done and joined hands and formed government and will become a chief minister. And then you say that, look, as far as I am concerned, the election commission will now decide whether, in fact, if this is the law, I think it bodes ill for the future of elected governments in this country. That's
Thank you, Mr. Yes, Mr. Yes, Dr.
I'll give it in point form. What is the crux of the case? Or the nature of the phrase voluntarily giving up membership of the party. Whereas in actual practice, 90 if not 95% of acts or omissions coming under 2(1)(a) relate to activities outside the house by the very nature. Examples out of hundreds. Going and was bashing the party or abusing it outside. Going to a rival party and accompanying them for toppling. Indeed, going to the governor with a rival faction. Now, all of these have nothing to do with what you are doing inside the house. Voting or not voting in a trust board, voting or not doing this, etc. A very important judgment of your lordships had occasion to consider it. I'm going to take only 5 minutes. Ravi Nayak. Before I cited the book out 1994, supplementary to SCC 641. Ravi Nayak was said that, and this is practical, no person comes and says, I have defected. While it's being given to your lordships, kindly appreciate the nuance of this clause. Nobody ever said, there is no case that says, I have done anti-party activities or I have defected.
He says, Speaker can infer.
The word is infer. The operative word on which Ravi Naik is based is it is inferred A and B by conduct. That's the heart of the principle. Just read para 11. Just that. Now this I will read to save time from the middle. All of 11 is important, but just read that middle practices. Middle of para 11, my lord. The said paragraph provides for disqualification of a member. They are talking of 2 of a house belonging to a political party. Quote, if he has voluntarily given up his membership of such political party. Unquote. The words voluntarily given up his membership are not synonymous with resignation and have a wider connotation. Now, kindly read this. This is what I am relying on, what is coming now. A person may voluntarily give up his membership of a political party even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, an inference, the operative word, can be drawn from the conduct, that's the second operative word, conduct, of a member that he has voluntarily given up the membership of the political party to which he belongs. Now, fellas, if this is the law, then your lordship's fellas has to consider, and not your lordship fellas, the persona designata exclusively constitutionally entrusted with this power is one person, the speaker. That persona designata will have to consider no one else. What you did in Surat, what you did in Guwahati, what you did outside, good, bad, or indifferent, what you did with the governor, is directly Ravi Naik. An inference can be drawn that you gave up. Now, if you gave up, then how do you operate clause 15 on the assumption that this is one faction of the party, this is another faction of the party? So, complete conceptual contradiction is my point number one. And that is what is happening. Point number two is, your lordship may kindly read again to save time, I'll not read it, the 4th of August 22 order of this honorable court. The last 4 lines, and we all appeared in this, was based on a clear understanding at that time by that honorable bench that the election commission would not proceed. And the last 4 lines of that read like this. According to the learned senior counsel, that is Mr. Tata, it says so. The proceedings may take some time as voluminous evidence is usually submitted by the parties which must be considered by the EC. The learned senior counsel therefore states that no orders may need to be passed by this court interdicting proceedings before the election commission. In these circumstances, we grant liberty to the petitioner to file an application before the EC for seeking time. Such applications are filed 3 times. Time was given with consent. There is no formal order, no doubt, but this is endured from the 3rd week of July till today as we speak in October. September. That is point number 2. Point number 3 is whether the balance of convenience clearly endured for further 1 month. If this is endured already, it does not at all cause them irreversible. However, your lordship's not protecting us causes us irreversible. That's point number 3. This is point number 4. This ground of IA. Lordship, I don't think should be catered by the form of an IA, but it's the substance of what we want. That's the simpler answer. But 2 more important answers in law. It would be, according to me, quite quaint if your lordship said that because it's an IA, the lordship can't decide this matter, it's outside the scope of the main matter. But there are 2 other answers, factually wrong. Number 1, we find several writs, including what your lordship will call the all-encompassing writ, which is number 493 of 22 on 8th of July. Prior to that, your lordship has 4 other writs in which this order of subject to outcome has also been passed. Prior. Election Commission is a subsequent development. It's as simple as that. It's a subsequent development. My writ 493 covers almost all the issues we have argued. 1 week, 10 days after the 8th of July, when I filed the writ, on 19th of July, this election commission is initiated. I filed an IA saying that this is a subsequent development. Why your lordship is hearing the main matter, please defer it. Because is that something so startling and beyond jurisdiction, like a fundamental lack of jurisdiction, that your lordship fellows cannot touch it? Therefore, that is, well, I hope, not their best argument. Now, Mills, one other thing, and I'm done. There is two paras of Rana very important. One, my learned friend Mr. Paul read para 25. He did not read para 27, which is the following para after one, which is very important. And the second para is 48. So these two paras I'll take 2 minutes on. My learned friend Mr. Paul read the sentence to be very
Para 27 and 48. There's
Yes.
just one more. Let me go to parameter.
27 is the answer to 25, so that the context is placed in 27, which follows has to be read along.
Just give a moment. Page 192, right?
Yes, so my learned friend read para 25 and he read this sentence actually, virtually the sentence alone. Para classical C. The power to recognize a separate group in parliament or assembly may rest with the speaker on the basis of the rules of business of the house. But that is different from saying that the power is available to him under the 10th schedule to the constitution, independent of a claim, mark word independent, of a claim being determined by him that a member or number of members had incurred disqualification by defection. That's a sentence Mr. Paul read. Now, the sentence which connects this is para 27 page later, where it is viewed as a continuum, as a part and parcel, and it is a continuum of split, merger, and disqualification. All are interconnected and have to decide by the speaker. Can you read that? This is para 27 from classical D for Delhi. In that context, the speaker cannot say that he will first decide whether there has been a split or merger. There are two concepts there. As an authority, and thereafter decide the question whether disqualification has been incurred by the members by way of a judicial adjudication sitting as a tribunal. Next sentence is crucial. It is part and parcel of his jurisdiction as a tribunal, while considering a claim for disqualification of a member or members, to decide that, but also in the context of the raised by those who are subject to that they have not incurred split in the party or in view of a merger. It is part of one continuous process of the speaker, who is a persona designata by the constitution, no less. Now, while your worship is on this, just let me finish on 48 of the same judgment. Also, not this great. This is just 2 lines. This is just to connect as one out of hundreds of examples, myriad examples which occur in 218 of voluntarily giving up. This case involved a very specific case. The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to an act of voluntarily giving up the membership in the party of which to get the said members and party. It is because all over the press and repeated that they went on this case with the other faction to the other party to the all admitted documents, all was on the record to the governor, doing exactly what Rana records in para 41. My 5th point is that your lordship is cited first. I want to make a general 5th point and then tell your lordship. I make bold to say, and I've checked with Mr. Devdas Kawat, who is very meticulous of this subject. 10 times I've told him. Not one single case. I repeat, lordship recorded by submission. It's a rather broad thing, I don't want to make no mistake. Not one single case where the interaction and interplay between a disqualified or disqualifying pending matter in a symbols case. Not one case I can't put it more widely than that, but I'm open to challenge on that. From that follows point number 6. One case is cited, which is Omar, etc. 1985, 4 SCC 628. Just note the citation I not taken off, just note the difference. The only case cited is 1985, 4 SCC 628, where para 1 notes that this is a challenge to the constitutional validity. For one. Number 2, no issue arising in that case of disqualification. Now we have the 10th schedule. What was the 10th schedule in a descriptive manner saying now we have 10 schedules, that's para 10. That one para becomes the springboard, erroneously and wrongly, of citing that case, suggesting that there is an interaction between the symbol's jurisdiction and disqualification. Nothing whatsoever. It's a completely inapplicable and irrelevant citation for this subject. May I end by saying, after thanking a lot for giving us time, that if the party, if there is, why, should we kindly go back to the origin? Why did the 10th schedule use 2 broad words? Actually, this intra-house issue was the whip issue normally. Of course, it can apply beyond the house also. I'm not saying, but I'm saying that was the focus. They deliberately and consciously used a very much wider concept. That concept falls directly in this issue to be decided one way or the other by the primary persona designata, the speaker's jurisdiction. It may or may not be peripherally decided later on, but because the primary direct custodian of 10th schedule is only one person. As a matter of fact, there are problems sometimes speaker is disqualified. Then the persona designata, you start doing hunting for a deputy speaker, which is strictly not legal. And then nobody there at all, then your lordship perhaps be interviewed. So therefore, your lordships will not short circuit this process. And no other procedure exists for deciding how to give a voluntary membership of party except what is here in 1A, which the speaker to his best ability decides. Today, in fact, your lordship is being asked to do 2 things by the other side. A, that this be decided first by the election commission. B,
what should be decided?
Decided first, what your lordship is told. I will let the EC decide it first. B, is the nature of what is a political party minus them or with them will be decided first, and thereafter the nature of the party will decide by the state.
That's just one submission
No.
for your lordship's kind consideration.
Have
Only on Kyoto Holo.
No, it cannot be.
There should be a Kyoto Holo. Mr. Rejoinder was cited. Just one second.
One sentence.
1 second. Perhaps Kyoto Holo said that while a show cause notice by a speaker is issued, no judicial review will lie till a final decision is taken. And that's why they're saying we ought not to have come at the stage when a notice was given to us on the 27th and when the order was passed. We came relying on Navam Rebia, which said the speaker cannot proceed with the matter. A constitution bench of this court had said the speaker will not initiate, continue, or proceed. So the issue was completely different, and their 32 is actually contrary to Kyoto because they are seeking this court to transfer all the jurisdiction of the speaker and decide it. And Mr. Sibbal presumes that we are disqualified and the EC today cannot be approached.
All right. First issue. Yes. We have heard Mr. Principal Dr. Abhishek Singhvi and Dr. Abhishek Singhvi council appearing on behalf of the application as the application for stay proceedings before the election commission. Mr. Maninder Singh has appeared on behalf of the private contesting parties. Stop. Mr. Tushar Mehta, then Solicitor General has appeared on behalf of the governor. Mr. Arun Detta, then Senior Counsel, has appeared on behalf of the Election Commission. Next. We've heard the. Sorry? Oh, yes, Mr. J.
What's it forgot me?
I'm so sorry.
No. Quite forget me.
No, not at all.
Apologies. Having heard the Election Council, we direct that there shall be no stay of the proceedings before the Election Commission. The IA seeking stay shall accordingly stand dismissed.
Very grateful. Extremely grateful.
Is allowed.